I can tell you with the greatest sincerity that I was not anticipating the nature of this press conference as we've witnessed the statements being made this morning. Rather, I was anticipating coming here and talking about the need to carry on the battle.
The Federal Court of Appeal has handed some Indigenous groups an important victory, and it means a huge setback for the Trans Mountain Pipeline expansion. The project is now stalled pending what the court says should be more meaningful consultation with First Nations communities. So how significant is today's ruling, and what kind of consultation do these First Nations want to see? Khelsilem is a Squamish First Nation council member and spokesperson, and he joins us from Vancouver. Hi there. Thank you so much for being with us. I appreciate it.
Thank you.
So we just heard from Stuart Phillips saying that this decision essentially came as a big surprise for him. That was not the press conference he thought he would be giving. Was it a surprise to you?
Personally, I would say, yeah, I was shocked. I was quite surprised. I'm quite happy to say that on behalf of the Squamish people, we're elated with the decision that the courts have recognized the comments and the position that our nation has made throughout this entire process, that when you engage with a First Nation, when you engage with our nation on a project of this scope, that the conversation, the relationship, the dialogue has to be meaningful, that it can't just be note takers coming to me, hear our concerns, and then do nothing about it. When we engaged, we gave, and the court acknowledged this, thorough and specific responses on this project, and nothing that we gave, none of the questions we asked, none of the information we asked for had a material impact on the NEB's report or on Cabinet's approval, which is why the courts have thrown it out.
If the court also gave recommendations pursuant to that, essentially directing the government to go back, meaningfully consult, and then go through the process again. If that were to happen, is there a possibility that your First Nations opposition to this would ever change?
Well, I think that we as a First Nation had a lot of serious concerns and serious legitimate concerns. Some of it was related to the lack of plans that were prepared for the event of an oil spill, but also part of it was what would happen to our inlet if there was an oil spill? What is the product that they're transporting through our territory? Our position as a nation, as a government, is that we have a jurisdiction to have a control and influence over what happens in our territory. Now, Canada is a country of laws. Canada is also a country that has been founded as a settler colonial country, which means that Indigenous nations were here before Canada existed. And Canada chose, through its constitution, through Section 35 of the Canadian Constitution, to respect Indigenous rights. And so Canada can't move forward unless it understands how to do that. And this court ruling really threw out all of the rhetoric that we've heard from Trudeau and his ministers about the thorough review that they've done on this project, the thorough consultation, and completely thrown it out and shown that it was inadequate, that they failed, that the report that the NEB submitted was inadequate, and that government shouldn't have even approved it. And that's really vindicated for us, because we've been trying to say that all along, but now we feel like somebody is actually listening.
What does it do to the greater, I guess, message or express goal of the government as far as reconciliation is concerned, right? The Prime Minister had stated right at the outset that was his main, one of, if not his main priority when he became Prime Minister. And so does this affect that?
Well, Trudeau, when he ran as a breath of fresh air after the decade under the Conservative Harper rule, where Indigenous rights were stampled on, where Indigenous rights were blatantly attacked, materially on the ground, we're not seeing much of a difference. And we've even hearing from the ministers that they're trying to blame the previous government for today's ruling. But the reality is that it was this government under this cabinet that approved the project, that they had a choice. And Trudeau, during the campaign, said that he would send the Trans Mountain project through a new environmental process, a new process that would be revamped from the Harper government. But they didn't. They got elected, they continued on with as status quo, and then they tried to tack on an additional consultation, which the courts today also even ruled were also inadequate. And so I think that this relationship between Trudeau and his government and the rhetoric that they've given has been a complete lie. And I've said today, and I'll continue to say, that Trudeau needs to stop picking fights with Indigenous people. And today's an example of that. We don't want to be in court fighting the federal government, but they're choosing to do that. And we're telling them, let's have a different relationship, but we're not seeing that on the ground yet.
Is there a decision, though, that you would accept if, I don't know how to properly define meaningful consultation, but if that definition is met and then the cabinet does decide again to approve the pipeline, though, is there a chance that you would ever support that decision?
Well, I think that it's a complex project that requires a lot of different facts to be established and a lot of understanding. The standard that the Squamish Nation and many First Nations have long argued for, and what the federal government has even in words promised to support, and what the provincial government here in BC has also support, which is the UN Declaration on the Rights of Indigenous People, which includes free, prior, and informed consent. Consent is a really important principle for us, that when you engage in meaningful consultation, that there has to be the possibility that our concerns are going to be addressed, that our issues are going to be heard, and that the impacts that this conversation has is going to change the outcome of what's proposed. And we haven't seen that so far. So it's really up to the government, up to the federal government, to decide how they're going to behave from this point forward, and whether that meaningful consultation, that free, prior, and informed consent that we're all looking for can happen. And the thing about this is that can happen in Canada. We can achieve a relationship where that is the law, that is the practice, that is on the ground, and everybody will benefit from that. First Nations are welcoming of the opportunities that exist for this economy. Part of the reason why the Squamish Nation has opposed this project is because of the threat to our economy. There is a future where we can build a better economy for all of our communities, but it really has to be founded on Indigenous rights.
I only have about 30 seconds left, but the decision today is being characterized, depending on who you ask, as the project being dead or simply a stumbling block. How would you characterize that?
I think that what we've heard from the Kinder Morgan as well is that the construction is going to cease. The project has been quashed so far. It's not continuing on for the foreseeable future. And depending on what the government decides to do, whether they take us to the Supreme Court, and I think many First Nations are willing to fight this to the end. So it's really up to the government to decide. But for the foreseeable future, this project is not moving forward. And the courts have thrown it out. They've celebrated, they've honored our rights, and we're celebrating that.
Okay, thank you so much, Khelsilem. I really appreciate your time.
Thank you.